this particular statute was not passed. I could go on. I will stop there for now, but that's certainly not the, we're probably going to disagree on a lot, but that's for openers.
I'll take Congress on my side. That's good enough for me.
Well, but for purposes of our discussion, there are two large constitutional issues, and maybe let's take them one at a time, just because they're separate enough, and we don't want to cross back and forth. So let's take the Progress Clause or Copyright Clause issue first. So Congress has the power to grant to authors and inventors for limited times the exclusive right to their respective writings and inventions. So what is the constitutional claim with respect to that clause?
So the limited times restriction, once you understand it in the context of the Copyright Clause and what preceded it, is a command to Congress. It is a command that Congress picks a specific date that's going to constrain copyright by marking its end. And the end is the key point. Time limits are about finality. And the lesson that was, I think, crystal clear, evident to the framers, based on British experience, is it is an endpoint with finality and permanent consequence that matters, because that was the thing that delivered all of these works, books, et cetera, in Britain from this system that had choked off for 200 years the distribution of books and the diffusion of knowledge, and it was only the Statute of Anne that solved that problem for Britain. And Britain spent about 70 years fighting about whether that time limit was going to have permanent consequences. They resolved that question. They answered yes in 1774, and so if there was any limit the framers knew, it was one that marked the end permanently. So if you understand the restriction to be one that tells Congress to pick the end, then the question becomes, okay, do we have to respect the choice Congress makes after we reach the limit Congress picks? And the answer is absolutely, because if Congress is free to just disregard an expiration date after it's passed, or their decision to say, no, this work doesn't get any protection at all, what's the limit? What's the end? The problem is, if you reach the end yesterday, or for that matter 50 years ago, you don't know if it's actually the end. If Congress can change its mind anytime it wants, forever into the future, there's no limit and there's no end. That's the problem with the limited times restriction.
So I'm interested in your reactions to the way the justices handled that, it turns out there are two pieces to the clause. There's the power to promote progress, and so before we talk about limited times, let me just ask about the progress. In Eldred, it was not litigated whether the Progress Clause actually constrains Congress's power, because there'd been a concession below. And in some of the questions, I at least heard an implication that the Progress Clause actually might